Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I'm going to talk to you about whether or not your ex-spouse can take something from your estate. Before I get into that, I'm going to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can find me on social media at Amanda Rocha Law, or you can comment down below if this platform allows you to do so. The reason that I decided to cover this topic is because I was reached out to by an ex-classmate of mine who had recently gone through a divorce and was extremely concerned after someone told her that her ex-spouse may be able to control or access some of her estate if something were to happen to her, which, not to alarm you, is true in certain instances. So I'm going to give you a few examples of how this could happen. The most common way in which your ex will actually take from your estate if something were to happen to you is if you fail to change your beneficiary designations on your life insurance policy and any other policy that you are required to name a beneficiary for. Even if you're divorced, most beneficiary designating accounts still will give that amount of money or whatever it is to the person named when you've passed away, regardless of whether you've had a divorce. Some states have rules against this. California does not have a rule against life insurance or anything else. In fact, when it comes to pension and other retirement account monies, it'll probably be covered in your divorce. So unless your divorce says something specific about these accounts, then you can assume that if you put money into an account during your marriage and you can't touch it because it's a pension or other retirement account, part of that at least will be community property when it comes time to actually collect it. So make sure that you check with your estate planning attorney and your divorce attorney if this is something that you are concerned about. Another way in which your ex could have some control over the proceeds of your accounts or anything coming out of your estate is if you have minor children or children who need someone to care for them as a dependent. In that case, if you fail to provide for a person as a caregiver or name someone as a trustee to make sure that the funds you leave behind are used for your children, then a court will usually side with the child's other living parent to be in charge of those funds. So if you have any concerns about that, it's very important that you actually create an estate plan to avoid that from happening. And if you have any issues and you have a current estate plan, you should definitely update that or speak with your estate planning attorney or any estate planning attorney to see what you can do to prevent that from happening. If you have any other questions or if you have this issue, you can contact me, like I said before, on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do so, or you can find me on social media at Amanda Rocha Law. Thank you.